What is Title IX? Title IX of the Education Amendments Act of 1972 prohibits sex discrimination in any federally funded educational program. Applies to all institutions receiving certain federal funds, including public schools, and includes all educational experiences the school offers, including academics, athletics, and extracurricular activities. Intended to avoid the use of federal resources to support discriminatory practices, and second, to provide individual citizens effective protection against those practices. What does Title IX cover? Title IX obligations arise in recruitment, admissions and counseling, financial assistance, athletics, sex-based harassment, treatment of pregnant and parenting students, discipline, single-sex education, and employment. A brief history of enforcement under Title IX. Regulations issued in 1975. Issued before any court interpretation of Title IX. Series of policy statements. 1997, Guidance Letter. 2001, Guidance Letter, revised the 1997 Guidance Letter. 2001, Dear Colleague Letter, withdrawn in 2017. 2014, Q&A, withdrawn in 2017. 2017, Q&A. Recent execute orders from President Biden related to sexual orientation and gender identity. June 16, 2021, the U.S. Department of Education's Office for Civil Rights, OCR, released a notice of interpretation explaining how it interprets Title IX to prohibit discrimination based on sexual orientation or gender identity. New regulations timeline consist of regulations that were first proposed in November 2018, followed by the notice and comments. Final regulations were issued on May 6, 2020. The final regulations went effective August 14, 2020. Why new regulations now? Department sought to define the conduct constituting sexual harassment for Title IX purposes. Specify the conditions that activate a recipient's obligation to respond to allegations of sexual harassment and impose a general standard for the sufficiency of a recipient's response, and specify requirements that such a response must include, such as offering supportive measures in response to a report or formal complaint of sexual harassment. Specify conditions that require a recipient to initiate a grievance process to investigate and adjudicate allegations of sexual harassment. Establish procedural due process protections that must be incorporated into a recipient's grievance process to ensure a fair and reliable factual determination when a recipient investigates and adjudicates a formal complaint of sexual harassment. What has changed? Requirement of a Title IX coordinator. Already required, new focus on ensuring that Title IX coordinator is impartial and separating decision-making functions from Title IX coordinator position. Requirement that Title IX coordinator be supported by investigators. Plaintiffs may make a report of sex discrimination, including sexual harassment, to the Title IX coordinator, in person, or by telephone, email, or postal mail. Dissemination of policy. Mercer County Schools does not discriminate on the basis of sex in the education programs or activities that it operates. Mercer County Schools is required by Title IX regulations not to discriminate in such a manner. Requirement not to discriminate in education programs or activities extends to student admission and employment. Inquiries about the application of Title IX may be referred to the Title IX coordinator, to the Department of Education, or both. Mercer County Schools is required to act on incidents of sexual harassment when it has actual knowledge of the sexual harassment, and it must institute corrective measures to address the sexual harassment. New definitions. Sexual harassment means conduct based on sex that satisfies one or more of the following. 1. An employee of the district conditioning the provision of an aid, benefit, or service of the recipient on an individual's participation in unwelcome sexual conduct. 2. Unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the district's education program or activity. Or 3. Sexual assault as defined in 20 U.S.C. 1092 F6 AV, dating violence as defined in 34 U.S.C. 12291 A10, domestic violence as defined in 34 U.S.C. 12291 A8, or stalking as defined in 34 U.S.C. 12291 A30. New definitions: sexual harassment, v15. Sexual harassment may include, but is not limited to, verbal harassment or abuse, such as graphic verbal commentary relating to an individual's body, sexual prowess or sexual deficiencies. Unwelcome or inappropriate letters, telephone calls, emails, pictures, cartoons, computer images, or other materials of a sexual nature. Sexual teasing, jokes, remarks, or questions. Commenting upon an individual's body or clothing in a sexually offensive manner. Sexually suggestive looks or gestures. Pressure, subtle or overt, for sexual activity. Unwelcome or inappropriate patting, pinching, or contact. Intentionally brushing against another's body. New definitions: sexual harassment. What might you consider to determine whether it is objectively offensive? The frequency, nature, and severity of the conduct. Whether the conduct was physically threatening or humiliating. The effect of the conduct on the alleged victim's mental or emotional state. Whether the conduct was directed at more than one person. Whether the conduct arose in the context of other discriminatory conduct. Whether the conduct unreasonably interfered with the alleged victim's educational or work performance. Whether the statement is a mere utterance of an epithet which engenders offense in an employee or student or offense by mere discourtesy or rudeness. Whether the speech or conduct deserves the protections of academic freedom or the First Amendment. What situations might lead to sexual harassment? Posting of sexually suggestive pictures. Consistently telling dirty jokes or stories in front of other employees. Tolerating staff or students who make sexually suggestive remarks about other staff or students within earshot of others. Allowing the use of derogative terms with a sexual connotation to be used to describe coworkers or students. Allowing frequent physical contact, even when it is not sexual. To be clear, non-sexual physical touching is itself not a Title IX violation, but frequent physical contact could erode boundaries to the point where touching becomes sexual. What constitutes sexual harassment? Occasional name-calling? Probably not, without more. Age matters. Overtly sexual comments or touching probably would be. Kiss without consent? Probably, even if a prior kiss was consented to. Multiple suggestive comments, jokes, vulgar language by an employee? Probably. Severe, pervasive, and objectively offensive. Sexually suggestive texts from teacher to student? Probably. New definitions. Actual knowledge means notice of sexual harassment or allegations of sexual harassment to a recipient's Title IX coordinator, or any official of the recipient who has authority to institute corrective measures on behalf of the recipient, or to any employee of an elementary and secondary school. Not met when the only person who knows is the alleged harasser. Notice also includes providing notice to the Title IX coordinator. Supportive measures means non-disciplinary, non-punitive individualized services offered as appropriate, as reasonably available, and without fee or charge to the complainant, or the respondent before or after the filing of a formal complaint, or where no formal complaint has been filed. Designed to restore or preserve equal access to the recipient's education program or activity without unreasonably burdening the other party, including measures designed to protect the safety of all parties or the recipient's educational environment, or deter sexual harassment. May include counseling, extensions of deadlines or other course-related adjustments, modifications of work or class schedules, campus escort services, mutual restrictions on contact between the parties, changes in work or housing locations, leaves of absence, increased security and monitoring of certain areas of the campus, and other similar measures. Must maintain as confidential any supportive measures provided to the complainant or respondent, to the extent that maintaining such confidentiality would not impair the ability of the recipient to provide the supportive measures. Title IX coordinator is responsible for coordinating the effective implementation of supportive measures. When to involve the Title IX coordinator, some examples. You are a teacher who overhears Mr. Keating, a veteran science teacher, asking Ms. Overstreet, a new math teacher, questions about her sex life. It appears to you that Ms. Overstreet is uncomfortable. What do? This should be reported to the Title IX coordinator. You could encourage Ms. Overstreet to report the conduct herself, but you have actual knowledge too, so if she doesn't report, you should. Mom reports to you, the school principal, that Neil has come home with a bruise on his arm. Neil told his mom that he's being bullied at school by Cameron, that it happens daily, and that Cameron has not stopped, despite Neil trying to address it both with him and the teacher. Neil's mom says the teacher isn't doing anything about it. Do you need to report to the Title IX coordinator? Probably not. This is a discipline issue that should be addressed through the student disciplinary procedures. What if Neil says that he believes Cameron is bullying him because Neil is homosexual? This is now possibly a Title IX issue, particularly if Neil's complaint is that he is being denied educational services because of Cameron's conduct or the teacher's lack of a response. You, a custodian working afternoons, are in the high school band room after school hours. You overhear Mr. Perry, the band teacher, talking to Ginny, a female student, in his office. You hear what you believe to be flirting, followed by Mr. Perry telling Ginny that he'd be willing to give her clarinet lessons if she's willing to do him favors in return. You hear Ginny reply that she's been hoping he'd ask, that she's like him since freshman year, and she's wanted to get with him. What do? This is quite possibly quid pro quo sexual harassment, and you should report it to the Title IX coordinator. It does not matter for quid pro quo sexual harassment of a student, whether it was unwelcome. Gerard, a principal, and Stephen, an assistant principal, are talking in the school's main office with Todd, the pro. You, a teacher, walk in to hear Gerard, Stephen, and Todd talking about how they've each wanted to hook up with Carla, the new school guidance counselor. The conversation continues while you make copies, including multiple references to sex and the three of them laughing. Do you need to tell the Title IX coordinator? Yes, you should. The Title IX coordinator might determine that this doesn't rise to the level of severe or pervasive conduct, but that's for the investigation to determine. Mercer County schools must act in response to a complaint of harassment in such a way as not to be deliberately indifferent. Clearly unreasonable considering the circumstances. Include sexual harassment that occurs of locations, events, or circumstances over which the recipient exercised substantial control over both the respondent and the context in which the sexual harassment occurs. Must treat complainants and respondents equitably by offering supportive measures to a complainant and by following a grievance process before the imposition of any disciplinary sanctions or other actions that are not supportive measures against a respondent. Title IX coordinator must inform complainant of supporting measures promptly and explain process of filing a complaint. Upon receipt of a complaint of sexual harassment, Title IX coordinator must provide a written notice of the allegations to the parties that must include sufficient details known at the time and with sufficient time to prepare a response before any initial interview. The identities of the parties involved in the incident, if known, the conduct allegedly constituting sexual harassment, and the date and location of the alleged incident, if known. Notice of the grievance process. A statement that the respondent is presumed not responsible for the alleged conduct, and that a determination regarding responsibility is made at the conclusion of the grievance process. A statement that they may have an advisor of their choice, who may be, but is not required to be, an attorney, and that they may review and inspect evidence. A statement that the parties cannot knowingly submit false statements. Investigating, the Title IX coordinator must permit each party to present evidence and witnesses. Not restrict either party to discuss the allegations or to gather and present evidence. Provide both parties the same opportunities to be accompanied by an advisor, who can be but need not be an attorney. Provide written notice of a hearing, if one is to be held. Provide both parties the evidence available, and allow the parties 10 days to provide a written response. Create a written report that summarizes the evidence and provide the parties an opportunity to respond. Decision maker, who cannot be Title IX coordinator or the investigator, must issue a written determination regarding responsibility, which must include identification of the allegations, description of the procedural steps taken, findings of facts supporting the conclusions, determination regarding the conduct and proposed discipline, notice of appeal rights, generally limited to procedural error, new evidence, undisclosed conflict of interest or bias. Diagram of the complaint investigation process. Complaint will be dismissed if, at any time, complainant asks to dismiss the complaint. The conduct alleged in the formal complaint would not constitute sexual harassment even if proved, did not occur in an education program or activity, or did not occur against a person in the United States. New procedures, informal resolution. Parties may engage in informal resolution with the Title IX coordinator. Parties must consent to participate in writing. Any party may withdraw at any time. Cannot be offered if the allegations are that an employee sexually harassed a student. Retaliation against the complainant prohibited. Identity of complainant and respondent are kept confidential outside of the parties to the proceeding. Review of First Amendment rights in schools. A student's First Amendment rights, while in school, are broadly protected. They may wear clothing that makes political, religious, or other statements. They may express their own beliefs. And nobody can restrict a student's dress merely because they disagree with the message. The only exceptions is the student's rights may be limited if they cause a substantial disruption or materially interfere with classroom activities, are considered lewd or vulgar, or encourage violations of the law. The staff's First Amendment rights are much more curtailed. May be prohibited from wearing clothing that makes political or religious statements. May not promote religious beliefs, and should not promote one political belief over another. Examples. Chet wears a t-shirt with the slogan, "Jesus hates abortion." Can the school require him to remove the shirt? No. Merely disagreeing with the message doesn't mean the shirt causes a substantial material disruption of the class. Another example. Russell wears a shirt to school that says, "Catholics are pedophiles." Can he be forced to remove it? Probably. Though students' freedom of speech is broadly protected, student speech can be restricted when it materially disrupts the classroom or is lewd, vulgar, or offensive. Russell's shirt is probably objectively offensive. Mrs. Welton, a Catholic and the school's guidance counselor, is deeply offended by the shirt. Can she talk to Russell about the church and her beliefs? No. Though Russell's speech can be restricted, allowing Mrs. Welton to discuss religious beliefs with him still creates an Establishment Clause problem. One last example. Chris is a Muslim student who wears the hijab, a religious headscarf, as a part of her observance of her sincerely held religious beliefs. The school's dress code strictly forbids hats and scarves. May Mrs. Danbury require Chris to remove the hijab? No. The school can regulate dress with a dress code, as long as the dress code is content neutral and is not biased. Chris should be entitled to a reasonable exception to accommodate her religious beliefs. What if Chris is a teacher? No, it's the same result.